Hi, this is Gayatri from Department of Commerce. Today's subject is business law. In that heading, contract of indemnity and guarantee. Contract of indemnity. According to section 124 of Indian Contract Act, a contract by which one party promises to save the another from losses caused to him by the contract of the promiser himself or by the contract of any other person. It is called a contract of indemnity. Here, a person who promises to protect another is called indemnifier. The person who is so protected is called indemnity holder. Once again, according to section 124 of Indian Contract Act, a contract by which one party promises to save the another from losses caused to him by the conduct of promiser himself or by the conduct of any other person. It is called contract of indemnity. The person who promises to protect another is called indemnifier. The person who is so protected is indemnity holder. Next, essentials of contract of indemnity. The first essential is essentials of valid contract. The second essential is indemnifier promises to save indemnity holder from the loss caused to him by the conduct of the promiser or by the conduct of any other person. This is second essential. The third essential is contract may be expressed or implied. Fourth, liability of indemnifier commences when the indemnifier suffers some losses according to the terms and conditions of the contract. Then the fifth essential is contract of insurance are also covered in this essentials. Next, nature of indemnity and extents of surety's liability. In general circumstance, the liability of surety arise only in case of default of indemnity. So, his liability is secondary. The liability of surety is coexisting with that of principal debtor. If liability of surety reduces, then surety's liability also reduces. When creditor recovers a part of his loan from property of principal debtor, then when liability of principal debtor reduces by order of court. These are all the extent of surety's liability. Next, discharge of surety from the liability. By revocation of contract of guarantee only for future transaction, he still remains liable if liability arises before giving notice. By surety's death, the estate of deceased is liable for transaction which has already taken place by novation. Next, by variance in the terms of contract. These are all discharge of surety from the liability. Some more points in discharge of surety of liability. By release or discharge of principal debtor. But if due to operation of law principal debtor is discharged, says on insolvency, surety is not discharged. Agreement with principal debtor regarding giving more time not to sue against him without giving consent of surety. Next, by Creditors Act or omission imparting surety's remedy, harming surety's interest. Next, by loss of surety by creditor, by innovating of guarantee obtained by misrepresentation, fraud, or in case of refusal of surety. Next, the liability of surety commences with default of the principal debtor. The creditor has the right to sue the surety even without taking action against the principal debtor. Liability of co-surety. These are all the discharge of surety for liability. Next, Next, rights of indemnifier. The following are the rights of indemnifier. First rights is rights under doctrine of suborganization to sue against third party after indemnifying the indemnity holder. Then third right is not to compensate for loss not covered under contract of indemnity. Next, rights of indemnity holder. Next, rights of indemnity holder. Section 125 states rights against claim for damages. Section 125 of 1. Claim for cost of suit. Section 125 of 2. Recovery of sum paid under conditions of compromise. Section 125 of 3. Next, rights of surety. The first right is right against debtor, right to subordinate, right to be indemnified, right against creditors, right to security, right to get information about debtors' conduct, right to set off in he has to settle his own amount from creditors. The next is rights against co-sureties, rights to claim contribution in case of co-sureties of equal amount, in case of co-sureties for different sums, in case of discharge of co-surety. These are all the contract of indemnity. Next, contract of guarantee. According to section 126 of Indian Contract Act, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of default. Parties involved in contract of guarantee: surety, principal debtors, and creditor. Contract of guarantee means, according to section 125 of Indian Contract Act, a contract of guarantee is a contract to perform the promise or discharge the liability of the third person in case of default. Here three persons involved in guarantee: surety, principal debtor, and creditor. Meaning of contract of guarantee. Guarantee means assurance. A contract of guarantee is a promise to be responsible for something, to perform the promise, or to discharge the liability of a third person. In case of his default, such a contract involves three parties: the creditor, surety, and principal debtor. Section 15 of 1 of Contract Act has provided the definition of a guarantee contract. A contract relating to a guarantee shall be deemed to have been concluded in case of provide that if any person default in repayment of loan obtained by him, or essential features of contract of guarantee. The first essential feature is the contract of guarantee must be written form. Section 15 of 3 of Contract Act. A AAA concurrent agreement between creditor, surety, and principal debtor. There must be not any misrepresentation or concealment of the facts regarding the contract. Next, a security for repayment of debt or performance of promise. No direct consideration contract between the surety and the creditor. Consideration of the principal debtor is considered to be sufficient for the surety. Fulfillment of the obligation accepted by him, it will be repaid or fulfilled by the third person. Definition for Indian Contract Act: a contract of guarantee is a contract to perform the promise or discharge the liability of the third person in case of his default. Then creditor means the person to whom the guarantee is given is called or is known as creditor. Surety, the person who gives the guarantee. Principal debtor, the person in respect of whose default the guarantee is given. Next, the difference between contract of indemnity and contract of guarantee. The first difference is purpose of contract. In contract of indemnity, to save the indemnified from loss caused to him by any event collateral to such a contract. In contract of guarantee, to provide necessary security to the creditor against his debt and credit to the principal debtor. First difference. Second difference is number of parties. In contract of indemnity, two parties involved: indemnity holder and indemnifier. In contract of guarantee, three parties involved: principal, debtor, surety, and creditor. Third difference is number of contracts. In contract of indemnity, there is only one contract between the indemnified and the indemnifier. In contract of guarantee, the difference collateral contracts between principal, debtor, surety, and principal, debtor, and creditor and surety. Next, nature of liability. Next difference is nature of liability. Primary liability is of indemnifier and arise immediately after loss from the collateral event in contract of indemnity. In contract of guarantee, secondary liability is of the surety and it arises only on the default of the principal debtor. Then the fifth difference is consideration. Liability, the consideration for the indemnifier is from the creation of the contract. In contract of guarantee, the consideration for the surety is not direct. The creditor's consideration is considered adequate to the security. Surety. Commencement of liability. Sixth difference is commencement of liability. Liability of the indemnifier arises after the happening of the collateral event. In contract of guarantee, commencement of liability arises of surety after the default by the principal debtor. Next difference is rights to reimbursement. The indemnifier has no rights to reimbursement of the amount paid to the indemnity holder. In contract of guarantee, the surety has the rights to reimbursement of the amount from the principal debtor which is paid to the creditor. Next difference is nature of contract. Indemnify is a contract of consignment nature. Guarantee is a contract of general nature. Next, number of promises. In indemnity, indemnifier is the only promiser for the loss of the indemnified party. In guarantee, the surety and the principal debtor are the two promisers for the debt of the creditors. Last difference is scope. The scope of indemnity is limited in itself. In guarantee, the scope of guarantee includes the indemnified too. Next, rights and duties of indemnifier. Happening of losses, occurrence of event, prudent act of indemnity holder, no negligence and bad intention involved. First, happening of losses. There must be a loss in accordance with the contract to make the indemnifier liable. Next, occurrence of event. There must be an occurrence of an anticipated event. Without any occurrence of the prescribed contingent event, there is no indemnity by the indemnifier. Next, prudent act of indemnity holder, where the rights of indemnity is used by the indemnity holder, prudent, and the instructions of the indemnifier is not contravened or when there is the breach of contract. Next, rights and duties of indemnity holder. Indemnity holder is the party who has been assured of the recovery of a loss by the indemnifier. He has made the provisions regarding the rights of the indemnity holder. The indemnity holder is entitled to recover any or all of the following amount of indemnity under the contract. All the indemnity amount mentioned in the contract. Second, All the damages may be compelled to pay a third party for the loss or damage. Next, if he is acting against the instruction of the indemnifier, if he works negligently, if he is acting with the intention of causing any loss or damage, if concerned or third parties suffer a loss thereof. Besides these, an indemnity holder can compel the indemnifier to make a payment even before the indemnity holder has met his liability. Next, all the costs spent on the case filed or defeated by him in connection with the contract relating to indemnity. Next, all the cost of legal actions if it becomes necessary to initiate such action for a failure to pay the amount mentioned in all the above cases. These are all the rights and duties of indemnity holder. Thank you.